The doorbell rang at 7:30 on a Monday morning in February, and I knew it was going to be trouble before I even opened the door. I had moved to my property on Clearwater Lane in Boulder, Colorado, just 6 months ago, buying the small 3-bedroom house that sat on 2 acres of land at the end of a long gravel driveway. The previous owner, an elderly man named Frank who had lived there for 40 years, had sold me the place for a reasonable price before moving to Arizona to be closer to his grandchildren. What I loved most about the property was its isolation. My house sat a good 300 yards from the main road, surrounded by pine trees and open space. The nearest neighbor was a quarter-mile away. When I opened the door, a woman in her mid-50s stood on my porch holding a clipboard. She had the kind of haircut that screamed manager, short and angular, and wore a puffy vest over a turtleneck despite the relatively mild morning. Her lips were pressed into a thin line that suggested she practiced disapproval in the mirror. "Good morning," she said, though her tone suggested it was anything but. "I'm Patricia Caldwell, president of the Clearwater Estates Homeowners Association. You must be the new owner." "Zachary Burton," I said, not opening the door any wider. "Can I help you?" "Yes, actually. We need to discuss your obligations to the community." She glanced down at her clipboard. "You have missed 2 mandatory snow removal rotations, and there was a significant snowfall last week that required additional volunteer hours." I blinked at her. "I'm sorry, what's snow removal rotation?" Patricia's expression tightened. "All homeowners within Clearwater Estates are required to participate in the winter snow removal rotation. We maintain the common areas and entrance, and everyone contributes either labor or pays the equivalent fee. You owe 6 hours of service or $300. "I think there has been a mistake," I said carefully. "I'm not part of any HOA." Her eyebrows shot up. "Excuse me. When I bought this property, there was no mention of an HOA. I reviewed all the paperwork with my lawyer. This house is not part of any homeowners association." Patricia's face flushed red. "That's impossible. Every property on Clearwater Lane is part of Clearwater Estates." "Not this one," I said firmly. "My property predates your development by decades. I'm not in your jurisdiction." "We will see about that," Patricia snapped. "I will be reviewing the records, and I expect to hear from you regarding your outstanding obligations. Ignoring HOA requirements is a violation that can result in liens against your property." She turned and marched down my driveway before I could respond. I watched her climb into a silver Lexus and drive away, her brake lights flashing angrily as she hit the potholes in my driveway. I closed the door and leaned against it, already feeling the beginnings of a headache. I had dealt with difficult people before in my work as a software developer, but there was something about Patricia Caldwell that promised particular aggravation. That evening, I pulled out all my closing documents and spread them across the dining room table. I had been thorough when purchasing the house, hiring a real estate attorney named Sarah Morrison to review everything. I found her business card and called her cell number. "Zachary," she answered warmly. "How is the new place?" "It's great, but I have a situation." The president of some HOA showed up this morning claiming I owe them money and labor for snow removal. She said all properties on Clearwater Lane are part of their association. Sarah was quiet for a moment. "That's interesting. Hold on, let me pull up your file." I heard typing on the other end of the line. "Okay, I'm looking at your property survey and deed right now. Your property is definitely not part of any HOA. The Clearwater Estates development was built in 1998, surrounding your property on 3 sides. But your parcel is what we call a grandfather property. It has been continuously owned since 1952 and has its own separate deed that predates the development." So I was right. Completely right. Your property has its own access easement to Clearwater Lane, which is a public road maintained by the county. You have no obligations to the HOA whatsoever. Did you get this person's name? Patricia Caldwell. She said she is the association president. Sarah sighed. I've heard of her. She's been involved in several disputes with residents. Listen, if she contacts you again, refer her to my office. Don't sign anything, don't pay anything, and definitely don't volunteer for any of their activities. Your property is legally separate. Thanks, Sarah, I appreciate it. No problem. And Zachary, document everything. People like Patricia don't give up easily, and you may need records if this escalates. I thanked her again and hung up, feeling more confident. But Sarah's warning about documentation stuck with me. I went to my computer and created a folder labeled HOA, then typed up notes about Patricia's visit, including the date, time, and everything she had said. 3 days later, I found a letter in my mailbox. It was on official Clearwater Estates HOA letterhead, addressed to me at my property address. Dear Mr. Burton, it began. This letter serves as formal notice that you are in violation of Clearwater Estates, HOA covenants and bylaws. You have failed to participate in mandatory community service requirements and have not responded to previous communications regarding outstanding fees. Your total obligation is now $450, which includes a late fee and administrative costs. Payment must be received within 10 business days to avoid further action, including the placement of a lien against your property. Failure to comply will also result in daily fines of $50. It was signed by Patricia Caldwell in aggressive handwriting, with HOA President printed beneath her signature. I took a photo of the letter and emailed it to Sarah Morrison, then filed the original in my growing HOA folder. Sarah called me back within an hour. This is harassment, and the threats are completely baseless. I'm going to draft a response on my firm's letterhead explaining that your property is not within their jurisdiction and demanding they cease all contact. I'm also going to CC their HOA's attorney if they have one listed. They're threatening liens and daily fines, I said. Can they actually do that? Not legally, no. They have no authority over your property. But they can certainly cause you headaches and waste your time, which is often the point. Some HOA boards become almost fanatical about enforcement, especially when they encounter properties that aren't under their control. It threatens their sense of authority. Great, I muttered. Sarah's letter went out the next day via certified mail. For about a week, things were quiet. I started to think maybe Patricia had gotten the message and would back off. Then I came home from grocery shopping on a Saturday afternoon to find an orange traffic cone placed at the end of my driveway with a laminated sign zip-tied to it. The sign read, "No parking, HOA violation, tow-away zone." I grabbed the cone and sign and threw them in my garage. 20 minutes later, my doorbell rang. This time it was Patricia and another woman, slightly younger with highlighted blonde hair and an expression that matched Patricia's disapproval. "Did you remove HOA property from the common area?" Patricia demanded before I could say hello. "I removed a traffic cone from my private driveway," I said. "Get off my property." "The first 15 feet of your driveway are actually within the HOA's maintenance easement," the blonde woman said. "I'm Deborah Winters, HOA treasurer. We have the right to place signage in common areas." "You don't have an easement on my property," I said. "And if you don't leave right now, I'm calling the police for trespassing." "We have every right to be here addressing violations," Patricia said, but she was already backing up. "No, you don't. My attorney has already sent you a letter explaining that this property is not part of your association. You have no jurisdiction here, and you need to stop harassing me." "This isn't over," Patricia said. "We'll be contacting the county about your property's status." "You do that," I said and closed the door. I immediately called Sarah Morrison again, even though it was Saturday. She didn't answer, so I left a voicemail explaining what had happened and that I had the sign and cone as evidence. Then I did something I probably should have done earlier. I called the non-emergency number for the Boulder County Sheriff's Office and explained the situation to the dispatcher. She took down my information and said a deputy would come by to take a report. Deputy Martinez arrived about 40 minutes later. He was in his early 30s, professional and thorough. I showed him the cone and sign, explained about Patricia's visits and the threatening letter, and provided copies of my property documents showing I wasn't part of the HOA. "This is technically a civil matter," Deputy Martinez said, "but the repeated unwanted contact after you've told them to stop could qualify as harassment. The false claims about towing vehicles could also be problematic. Do you want to file a formal complaint?" "Not yet," I said. "I'm hoping they will back off now that my attorney has gotten involved, but I wanted this documented in case it escalates." "Smart," the deputy said. "Keep records of everything. If they come back onto your property after you've explicitly told them not to, that's criminal trespass. Call us immediately if that happens." He gave me a case number and left. I felt a bit better knowing there was an official record, even if nothing would come of it immediately. Monday morning, Sarah called me. "I got your voicemail. This is getting out of hand." I did some research over the weekend, and I think I know what's happening. The HOA has been trying to buy your property for years. They approached the previous owner multiple times with offers. They want to tear down your house and build 2 or 3 new homes on your acreage, which would bring in substantial HOA dues. "Frank never mentioned that," I said. "He probably didn't think it mattered since he wasn't selling to them. But now that you own it, they're trying to either force you out or bring you under their control. If they could successfully claim jurisdiction over your property, they could fine you into submission and eventually foreclose." "That's insane." "That's HOA politics," Sarah said grimly. "The good news is they have absolutely no legal ground to stand on. The bad news is they might not care and could keep harassing you anyway. I'm going to send another letter, this one more strongly worded, threatening legal action if they continue. I'm also going to reach out to their attorney directly if I can identify who represents them." "Thanks, Sarah. Bill me for whatever this takes." "Will do. And Zachary, consider installing some security cameras. If they're brazen enough to put signs on your property, they might try other things." That afternoon, I ordered a complete security camera system online with overnight shipping. By Tuesday evening, I had cameras covering my driveway entrance, front door, back door, and the sides of my house. Everything recorded to a cloud service with motion detection alerts sent to my phone. The cameras proved their worth sooner than I expected. Wednesday morning at 6:15, my phone buzzed with a motion alert. I groggily checked the camera feed to see a pickup truck pulling into my driveway. 2 men got out carrying shovels and a bag of what looked like rock salt. I threw on clothes and rushed outside. The men were spreading salt across my driveway, which was already clear because I had shoveled after the last snowfall. "What are you doing?" I called out. The men looked up, startled. One of them, a guy in his 50s wearing a Clearwater Estates vest, said, "We're taking care of the snow removal since you haven't participated in the rotation." "I never asked you to do that, and you're trespassing. Leave now." "We have authorization from the HOA board," the other man said. He was younger, maybe early 30s. "All properties require winter maintenance." "Not this property. You need to leave immediately or I'm calling the police." The older man started to argue, but the younger one grabbed his arm. "Come on, Jerry, this isn't worth it." They loaded their tools back into the truck and left, but not before Jerry yelled out his window, "You'll get a bill for services rendered." I had the entire interaction on camera, and I immediately sent the footage to Sarah Morrison. She called me back within minutes, and I could hear the anger in her voice. "This has crossed a line," she said. "They're now trespassing and attempting to create false debt. I'm drafting a cease and desist letter today, and I'm going to recommend you file for a restraining order against Patricia Caldwell and the HOA board if they make any further contact." "A restraining order seems extreme," I said. "They sent people onto your property at 6 in the morning without permission after you've repeatedly told them to stop. A judge will see this as harassment. Trust me, sometimes you need to escalate to make bullies back down." "Okay," I agreed. "Let's do it." That afternoon, Sarah filed a petition for a civil harassment restraining order with the Boulder County Court. The hearing was scheduled for the following week. In the meantime, the HOA and its board members were prohibited from contacting me except through attorneys. I thought that would be the end of it. I was wrong. Friday evening, I returned home from work to find my mailbox had been removed from its post. The post was still there, but the mailbox itself was gone. In its place was a note wrapped in plastic that read, "Mailbox removal due to HOA violation. Non-compliant structure. Retrieved from HOA office." My mailbox had been there for decades. It was a simple black metal box on a wooden post, nothing fancy, and certainly nothing that violated any code since there was no code that applied to my property. I took photos of everything, including the note, and called the sheriff's office. This time, I explicitly said I wanted to press charges for theft and property damage. Deputy Martinez came out again, accompanied by another deputy named Torres. They documented everything and took the note as evidence. "You know where this HOA office is?" Deputy Martinez asked. "I assume it's somewhere in the Clearwater Estates neighborhood, but I don't have an address." Deputy Torres looked it up on his phone. "They have a community building at 450 Clearwater Boulevard. That's about half a mile from here." "We'll go have a conversation with them," Deputy Martinez said. "In the meantime, I'd suggest installing a temporary mailbox for now. You can file a victim impact statement and pursue charges if we find evidence of who took it." The deputies left, and I drove to the hardware store to buy a new mailbox. I installed it before dark, this time adding a small security camera pointing directly at it. Saturday afternoon, Deputy Martinez called me. We spoke with the HOA president, Patricia Caldwell. She claims she has no knowledge of any mailbox removal and suggested perhaps it was damaged and fell off. We explained that's not consistent with the evidence and that this is now a criminal investigation for theft and property damage. We also informed her about your pending restraining order hearing and advised all board members to have no contact with you. What did she say? She was not happy, but she acknowledged the warning. She also kept insisting your property is under HOA jurisdiction and that you're violating multiple covenants. I explained that's a civil matter for courts to decide and irrelevant to the criminal matter of taking your property. Do you think it will stop now? Deputy Martinez was quiet for a moment. In my experience, people who go this far usually don't stop until they face real consequences. Be vigilant, keep your cameras running, and don't hesitate to call if anything else happens. The restraining order hearing was scheduled for Tuesday afternoon. Sarah Morrison had prepared a thick packet of evidence. Photos of the signs, copies of the threatening letters, camera footage of the trespassing incidents, photos of my stolen mailbox, and the police reports. She had also included documentation proving my property was not part of the HOA. Patricia Caldwell showed up with an attorney, a nervous-looking man in his 60s named Robert Chen. The hearing was held before Judge Catherine Yamamoto in a small courtroom in Boulder. Sarah presented our case methodically, walking through each incident and providing documented evidence. Your Honor, Mr. Burton has repeatedly informed the HOA that his property is not within their jurisdiction. Despite this, and despite a formal letter from my office, the harassment has escalated to include trespassing, theft, and property damage. We're asking for a restraining order prohibiting any contact between the HOA board members and Mr. Burton. Robert Chen stood up, looking uncomfortable. Your Honor, there seems to be a misunderstanding about property boundaries, and Judge Yamamoto held up her hand. Counselor, have you reviewed the property documents submitted by Miss Morrison? I have, Your Honor, but the HOA maintains that the property documents clearly show Mr. Burton's land is not part of the Clearwater Estates development and predates it by decades. Do you have any evidence to the contrary? Robert Chen shuffled papers. No, Your Honor, but then the HOA has no jurisdiction over Mr. Burton's property, and their actions constitute harassment. I'm granting the restraining order. Miss Caldwell and all members of the HOA board are prohibited from contacting Mr. Burton directly or indirectly, from entering his property, and from making any further claims about HOA obligations regarding his property. The restraining order will be in effect for 1 year, at which point Mr. Burton may petition for renewal if necessary. Patricia Caldwell stood up, her face red. Your Honor, this is ridiculous. He's a property owner on Clearwater Lane and he needs to Miss Caldwell, Judge Yamamoto said sharply. You are not helping your case. One more outburst and I'll hold you in contempt. Your attorney can file an appeal if you disagree with my ruling, but my decision stands. You are to have no contact with Mr. Burton. Do you understand? Yes, Patricia said through clenched teeth. I need you to acknowledge verbally that you understand the terms of this restraining order, the judge continued. I understand, Patricia said, her voice tight. Judge Yamamoto signed the order and handed copies to both attorneys. Miss Morrison, if your client experiences any violations of this order, contact law enforcement immediately. Violations will result in contempt charges and possible criminal penalties. We left the courtroom, and I felt relief wash over me. Thank you, Sarah. Hopefully this is finally over. Sarah gave me a sympathetic look. I hope so too, but keep your guard up. We've legally established that they have no claim to your property, but people like Patricia Caldwell don't like losing. Just stay alert. For 2 weeks, everything was quiet. The snow started melting as March arrived, and I began to relax. I worked from home most days, enjoying the peace of my property and the views of the mountains. Then, on a Monday morning, I received a notice from Boulder County Code Enforcement. It stated that complaints had been filed about my property regarding zoning violations, including unauthorized structures, improper drainage, and fire hazard concerns. An inspector would be visiting within 48 hours to assess the claims. I called Sarah immediately. They're going after me through the county now. Of course they are, Sarah said tiredly. It's a common tactic. File complaints with every government agency possible, hoping something sticks. The good news is that if your property is up to code, which I'm sure it is, the inspection will clear you. The bad news is you have to deal with the hassle. Can we prove the HOA filed the complaints? Probably not directly. They'll have done it anonymously or through individual members rather than officially. but the timing is suspicious given the restraining order just went into effect. The county inspector, a woman named Helen Rodriguez, came out Wednesday morning. She was professional and thorough, spending 2 hours examining my property with a checklist. "I'll be honest with you," she said as she finished up. "I see nothing concerning here. Your structures are all permitted and up to code according to county records. Your drainage is actually better than most properties in this area, and you've maintained good defensible space for fire prevention. I don't know who filed these complaints, but they appear to be baseless." "Can I get something in writing?" I asked. "Absolutely. I'll file my report with the county and you'll receive a letter within a week stating that no violations were found. If you get any more harassment about this, refer them to my report." After Helen left, I called Sarah to update her. She was pleased but not surprised. The HOA is going to keep trying different angles. They've invested too much energy into this to back down easily. Just keep documenting everything. The following week, I received 3 more notices. One from the county health department about alleged septic issues. One from the fire department about supposed fire code violations. And one from the county assessor's office questioning my property boundaries. Each complaint required me to take time off work for inspections or meetings. Each inspection found no issues. Each agency representative seemed annoyed that their time was being wasted with frivolous complaints. "This is getting ridiculous," I told Sarah after the 3rd inspection. "They're weaponizing government agencies against me." "Yes, and that's actually good news for us," Sarah said. "We're building a pattern of harassment that goes beyond the initial incidents. If this continues, we can pursue a civil lawsuit against the HOA for harassment and abuse of process. We might even be able to get damages for your lost time and attorney fees." "I just want them to leave me alone," I said. "I know, but sometimes the only way to make a bully stop is to punch back hard enough that they realize it's not worth it. Let's give it another couple of weeks, document every incident, and then we'll discuss filing a lawsuit." That weekend, I was working in my yard when I noticed someone with a camera standing at the end of my driveway, taking pictures of my property. When I walked toward him, he quickly got into his car and drove away. The following Tuesday, I received a letter from a law firm in Denver that I didn't recognize. It informed me that the Clearwater Estates HOA was filing a lawsuit against me for various property violations and seeking enforcement of HOA covenants. I immediately forwarded the letter to Sarah. She called me back within an hour, and she sounded almost gleeful. "They just made a huge mistake," she said. "By filing this lawsuit, they've violated the restraining order, which prohibits them from making claims about HOA obligations regarding your property. The judge specifically included that language. I'm going to file a motion for contempt and also file our own countersuit for harassment, abuse of process, and intentional infliction of emotional distress." "Intentional infliction of emotional distress," I repeated. "It's a tort claim." "Basically, we'll argue that their pattern of harassment was so egregious and intended to cause you emotional harm. With everything that's happened, we have a strong case. Plus, filing a baseless lawsuit in violation of a restraining order really strengthens our position." The legal maneuvering accelerated. Sarah filed the contempt motion and our countersuit the next day. Patricia Caldwell and 2 other board members, Deborah Winters and a man named Craig Thompson, were summoned to court to explain why they should not be held in contempt. The hearing was scheduled for 3 weeks later, but things heated up even before that. I started receiving phone calls from blocked numbers. When I answered, no one spoke, but I could hear breathing. I stopped answering blocked calls and let them go to voicemail. The calls came at all hours, sometimes as late as 2 in the morning. Someone also started driving past my property slowly at night. My security cameras caught the same silver Lexus that Patricia drove going past my driveway entrance multiple times between midnight and 2 in the morning on several occasions. I provided all of this to both Sarah and the sheriff's office. Deputy Martinez came out again and reviewed the camera footage. "That's definitely harassment," he said. "The phone calls could be anyone, but the repeated drive-bys are concerning. We can increase patrols in your area. If you see the vehicle actually enter your property, or if anyone approaches your house, call 911 immediately." The night before the contempt hearing, someone spray-painted HOA violator on my driveway in orange paint. My cameras caught two figures in dark clothing and ski masks doing it around 3 in the morning. They had parked on the main road and walked up my driveway on foot. I called 911 immediately. 2 deputies arrived within 10 minutes, but the perpetrators were long gone. They took photos and a report, and Deputy Martinez, who arrived shortly after, examined the camera footage closely. The body types and movements match a female in her 50s and a heavier-set male, he said. That could fit Patricia Caldwell and Craig Thompson, the board members you mentioned, but we can't make a positive identification from this footage. I'm going to include this in my report to the judge, though. The timing right before your hearing is not coincidental. Sarah was furious when I sent her the photos and video the next morning. "Bring printed copies to court today," she instructed. "We're showing the judge everything." The contempt hearing was intense. Judge Yamamoto reviewed the evidence of the HOA's lawsuit filing, the anonymous complaints to government agencies, the phone harassment, and the vandalism. Robert Chen, the HOA's attorney, tried to distance his clients from the worst incidents. "Your Honor, we have no evidence that Miss Caldwell or any board members were involved in vandalism or phone harassment. The lawsuit was filed on advice of counsel based on legitimate concerns about property use." Judge Yamamoto was not impressed. "Counselor, I specifically ordered the HOA to make no further claims regarding Mr. Burton's property. Filing a lawsuit doing exactly that is a clear violation of my order. As for the other incidents, the pattern and timing strongly suggest involvement by your clients or people acting at their direction." She turned to Patricia Caldwell, who sat rigidly in her seat. "Miss Caldwell, you have violated the restraining order. I'm holding you and the HOA board in contempt. You are each fined $1,000, and I'm extending the restraining order for an additional 2 years. I'm also referring this matter to the district attorney's office to consider criminal charges for vandalism and harassment." Patricia's face went pale. "Your Honor, I have done nothing wrong. I'm simply trying to enforce legitimate HOA rules. The rules don't apply to Mr. Burton's property, as has been established repeatedly," Judge Yamamoto said. "Your continued insistence otherwise borders on delusional. If you or anyone associated with the HOA has any further contact with Mr. Burton, I will not hesitate to impose jail time for contempt. Do you understand me?" "Yes, Your Honor," Patricia said quietly. "And regarding the countersuit filed by Mr. Burton," the judge continued, "I'm allowing that to proceed. Given the evidence I've seen today, Mr. Burton has substantial grounds for his claims. I strongly suggest the HOA consider settlement negotiations, because if this goes to trial, I suspect a jury will not be sympathetic to your actions." We left the courthouse, and I felt a mixture of vindication and exhaustion. "Is it really over now?" I asked Sarah. "The criminal part might be, depending on what the DA decides to do. The civil suit will continue, but I think we'll get a settlement offer soon. The judge basically told them they're going to lose. 2 days later, the Boulder County District Attorney's Office announced they were charging Patricia Caldwell and Craig Thompson with criminal mischief and harassment based on the vandalism and phone call evidence. The DA's press release mentioned the unusual case of HOA board members criminally harassing a homeowner not even in their jurisdiction. The story was picked up by local news. A reporter from a Denver television station called me for an interview. I agreed, figuring it might help prevent this from happening to someone else. The interview aired that evening on the 6 o'clock news. I explained the whole situation, from Patricia's first visit to the vandalism. The reporter had also interviewed Sarah Morrison, who explained how some HOA boards become drunk on their limited power and overreach dramatically. The story went viral on social media. I started getting messages from people across the country sharing their own HOA horror stories. Several news outlets contacted me for follow-up interviews. The national attention seemed to embarrass the Clearwater Estates HOA. A week after the news story aired, Sarah received a call from Robert Chen proposing a settlement. The HOA would pay me $50,000 in damages, cover all my attorney fees, issue a public apology, and agree to a permanent injunction prohibiting any contact with me or claims about my property. That's more than I expected, I told Sarah. What do you think? I think we could probably get more if we went to trial, given all the publicity and the criminal charges, Sarah said. But trials are time-consuming and unpredictable. This settlement gives you everything you really want: money for your trouble, complete vindication, and a guarantee they'll leave you alone. Let's take it, I said. I just want this over. The settlement was finalized within 2 weeks. The HOA issued a statement to all residents and local media, admitting they had mistakenly harassed me and acknowledging my property was not under their jurisdiction. They apologized for their actions and promised policy changes to prevent similar situations. Patricia Caldwell resigned as HOA president the day after the settlement was announced. I heard through local gossip that she and her husband were planning to move out of state. The criminal case against Patricia and Craig Thompson proceeded separately. Both eventually pleaded guilty to misdemeanor harassment charges and were sentenced to probation, community service, and ordered to pay restitution for the damage to my property. They were also permanently barred from serving on any HOA board in Colorado. 3 months after everything was resolved, I was finally able to relax and enjoy my property in peace. The snow had melted completely, and I spent my weekends working in the yard and planting a garden. One Saturday morning in early May, I heard a vehicle coming up my driveway. My stomach tightened instinctively, but when I checked the security camera, I saw it was Deputy Martinez in his patrol car. I went outside to meet him. "Is everything okay?" I asked. "Everything's fine," he said with a smile. "I was in the area and wanted to check on you. Make sure you haven't had any more trouble." "It's been quiet," I said. "Really quiet, actually. It's nice." "Good. I'm glad it worked out. That was one of the stranger cases I've dealt with. HOA disputes usually don't escalate to criminal charges." "I appreciate all your help," I said. "If you hadn't taken it seriously and documented everything, I don't think it would have been resolved so cleanly." "Just doing my job," Deputy Martinez said. "But I'll admit, it was satisfying to see consequences for once. Too often these situations drag on without resolution." After he left, I walked around my property, appreciating the peace. The pine trees swayed in the breeze and I could hear birds singing. The mountains were visible in the distance, still snow-capped. I thought about Frank, the previous owner, and how he had lived here peacefully for 40 years. The HOA had probably tried to pressure him too, but he had simply outlasted them. I understood why he loved this place enough to stay so long. That evening, I was grilling dinner on my back deck when my phone rang. It was Sarah Morrison. "Just wanted to give you a final update," she said. "The settlement check cleared and I've deducted my fees as agreed. I'm having the balance transferred to your account. You should see it within a business day or two. Thanks, Sarah, and thank you for everything. You went above and beyond." "It was an interesting case," she admitted. "And between you and me, it was satisfying to knock down an overbearing HOA. I've seen too many people get steamrolled by these organizations because they don't know their rights. You think they learned their lesson, the HOA? Probably not entirely. But they'll think twice before going after someone's property without making sure they actually have jurisdiction. And the individual board members definitely learned consequences are real." After we hung up, I sat on my deck watching the sunset paint the mountains in shades of orange and purple. The whole ordeal had been stressful and time-consuming, but I had learned valuable lessons about standing up for myself and not backing down when I was in the right. The next week, I received an envelope in my mailbox. Inside was a handwritten note on plain paper. It read, "Mr. Burton, I am a homeowner in Clearwater Estates and wanted to thank you for standing up to the board. Several of us have been unhappy with their overreach for years, but were too intimidated to fight back. Your case gave many of us courage. We held a special election and voted in an entirely new board. The new president is focused on actual community maintenance and reasonable enforcement, not petty tyranny. Thank you. A grateful neighbor." The note was unsigned, but it made me smile. Maybe some good had come from the whole mess after all. As summer arrived, I settled into a comfortable routine. I worked from home during the week, took care of my property on weekends, and enjoyed the isolation and natural beauty that had attracted me to the place originally. One afternoon in June, I was working in my front yard when a car pulled up at the end of my driveway. I tensed briefly, old habits from the HOA conflict kicking in, but relaxed when I saw it was just a young couple looking at a house for sale in the neighborhood. The woman rolled down her window. "Excuse me, do you live here?" "I do," I said, walking over. "We're thinking about buying a house in this area," she said. "How do you like it?" "It's great," I said honestly. "Beautiful, quiet, good community." "What's the HOA like?" her husband asked from the driver's seat. I smiled. "Depends on whether you're actually in the HOA or not. If you're buying, I'd strongly suggest having a real estate attorney review your documents carefully to confirm the property's status before closing." They looked puzzled, and I gave them Sarah Morrison's business card. She's excellent. Thorough and protective of her clients. Tell her Zachary Burton referred you. After they drove away, I went back to my yard work, feeling content. My property was truly mine without any overlord HOA dictating what I could or could not do. The battle had been frustrating and at times infuriating, but standing my ground had been worth it. That evening, I sat on my deck with a cold beer, watching fireflies emerge as dusk settled over the property. My phone buzzed with a news alert. The headline read, "Colorado introduces bill to reform HOA powers following high-profile harassment case." I clicked the link and read that a state legislator had proposed new regulations limiting HOA enforcement actions and requiring clearer documentation of property boundaries before HOAs could claim jurisdiction. The article specifically mentioned my case as an example of HOA overreach. I forwarded the article to Sarah with a note. "Looks like we might have changed something bigger." She responded within minutes. That's the best outcome we could hope for. Your willingness to fight back publicly might help a lot of other people avoid similar situations. As the stars came out overhead, I reflected on the past several months. The harassment from Patricia Caldwell and the Clearwater Estates HOA had been aggressive and at times frightening, but the legal system had ultimately worked. The restraining order, contempt charges, criminal prosecution, and civil settlement had all combined to deliver justice. More importantly, I had learned that having clear documentation and legal representation made all the difference. If I hadn't kept detailed records or hired Sarah Morrison, the outcome might have been very different. The HOA might have worn me down with constant harassment until I either gave in or sold the property. Instead, I was sitting peacefully on my own land, secure in the knowledge that my property rights were protected by law and court order. Patricia Caldwell and her aggressive board were gone, facing criminal records and financial penalties for their actions. The new HOA board had sent me a brief formal letter shortly after taking office, simply acknowledging that my property was not in their jurisdiction and wishing me well as a neighbor. It was the kind of reasonable communication that should have happened from the start. I finished my beer and headed inside as the night air grew cool. Tomorrow, I had a video conference with work, and then I planned to start building a garden shed in my backyard. No one would tell me I couldn't. No one would fine me for the color I painted it or its placement on my land. That freedom, the simple freedom to use my own property as I saw fit within reasonable legal limits, was what I had fought for. And it was worth every moment of frustration and every dollar spent on legal fees. As I locked up for the night and checked my security cameras one last time, I felt grateful. Grateful for good legal representation, for law enforcement that took the situation seriously, for a judge who saw through the HOA's tactics, and for the rule of law that protected individual property rights. The cameras showed nothing but the peaceful darkness of my driveway and the woods beyond. No suspicious vehicles, no trespassers, no harassment. Just the quiet night on my private property, exactly as it should be. I slept well that night, better than I had in months, knowing that the battle was truly over and I had won. The months that followed were blissfully uneventful. I completed my garden shed, planted vegetables in raised beds, and even adopted a dog from the local shelter, a German Shepherd mix named Zeus who loved running around the acreage. By the time autumn arrived and the leaves started changing colors, the HOA conflict felt like a distant memory. I occasionally saw neighbors from Clearwater Estates at the local grocery store or hardware shop, and they were uniformly friendly. Many had heard about the case and expressed support for how I had handled it. The criminal cases against Patricia Caldwell and Craig Thompson concluded in September. Both completed their community service requirements and probation terms without incident. Patricia and her husband did move away, relocating to Florida according to neighborhood gossip. Craig Thompson kept a much lower profile, and I never encountered him directly. The settlement money had more than covered my legal expenses and lost time from work. I used part of it to make improvements to my property, including upgrading my well system and adding solar panels. The rest went into savings and investments. Sarah Morrison and I stayed in touch. She occasionally sent me articles about HOA reform legislation or court cases involving property disputes. The bill inspired by my case passed the Colorado legislature and was signed into law, creating new protections for homeowners and penalties for HOAs that engaged in harassment or claimed jurisdiction over properties not actually under their control. 1 year after Patricia Caldwell first knocked on my door, I was sitting on my deck on a crisp February morning, drinking coffee and watching Zeus chase squirrels in the yard. My phone rang and I saw it was Sarah. "Hey, Sarah," I answered. "What's up?" "I just got an interesting call," she said. "Remember Robert Chen, the HOA's attorney?" "Of course. He's representing a new client in a similar situation to yours. An HOA in Fort Collins is claiming jurisdiction over a property that predates their development. He asked if you would be willing to speak with his client about your experience." I thought about it for a moment. "Yeah, I'd be happy to. Give them my number." "Will do. I think your case really made an impact, Zachary. People are less willing to be pushed around by overreaching HOAs now." After we hung up, I sat thinking about the journey. What had started as an irritating confrontation with an aggressive HOA president had turned into a months-long battle involving lawyers, police, courts, and criminal charges. It had been stressful and time-consuming, but ultimately rewarding. I had protected my property rights, held bad actors accountable, and potentially helped change laws that would protect others. The experience had taught me the importance of knowing your rights, documenting everything, and not backing down when you are clearly in the right. Zeus bounded up onto the deck and laid his head on my knee, looking up at me with happy dog eyes. I scratched behind his ears and looked out at my property, my land, my home. No HOA could take this away from me. Not Patricia Caldwell with her clipboard and demands, not the aggressive board with their harassment and threats, not anyone. The law had been clear, and justice had prevailed. That was all I had ever wanted. Just to be left alone on my own property, living peacefully without interference from people who had no authority over me. And now, finally, I had exactly that. The snow would fall again soon, and I would shovel my own driveway on my own schedule, without anyone telling me it was my turn in a rotation I was never part of. My mailbox would stay where I put it. My property would be maintained to my standards, not someone else's arbitrary rules. I raised my coffee mug in a silent toast to Frank, the previous owner who had peacefully lived here for 4 decades before me. He had understood the value of this place, this independence, this freedom from petty bureaucrats with overinflated authority. Now I understood it too, hard-won through conflict but appreciated all the more because of it. As I went back inside to start my workday, Zeus following at my heels, I glanced at the framed copy of the final settlement agreement hanging in my home office. It was a reminder of what I had fought for and won. Below it hung the certificate from the county inspector confirming my property met all codes, the letter from the new HOA board acknowledging I was not in their jurisdiction, and a printout of the news article about the Colorado HOA reform law. Together, they told a complete story. An ordinary homeowner had stood up to an overreaching organization, refused to be bullied or intimidated, and had ultimately prevailed through documentation, legal representation, and the rule of law. It was a story I would share with anyone who asked, because maybe it would give someone else the courage to stand up for their rights too. That was perhaps the most valuable outcome of all. The rest of that winter passed peacefully. I shoveled my driveway when I wanted to, decorated my property for the holidays however I pleased, and lived without the cloud of HOA harassment hanging over me. When spring came again, bringing with it warming temperatures and the return of migratory birds, I planted more gardens and added a small pond in my backyard. Zeus loved splashing in the shallow water on hot days. Life was good. Simple, quiet, and completely under my own control. That's all I had ever wanted, and that's exactly what I had fought for and won. The battle with the Clearwater Estates HOA was over, decided decisively in my favor, and I could finally enjoy my property in peace.